All right, Ronald Allen. All right, can I get a file stamp, please? No problem. Court is calling 2025 CR 007563, State versus Ronald Lamar Allen. Can I have parties announced?
Lawrence Smith, State.
Here we go again. Ronald Allen steps up facing a third-degree felony for terroristic threats against a public servant. Range, up to 10 years in prison and a $10,000 fine, but the twist? He's hoping for deferred adjudication, a chance to dodge prison if he can stay out of trouble.
Charles W. Booker for the accused. Ronald Allen.
All right. Counsel, you received all discovery?
Yes, I did, Judge.
And did you review that with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Allen, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, I did.
Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes, I did.
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Allen, did you review the court admonishments and waivers with your attorney?
I did.
Did you understand it and sign it in all the appropriate places?
I did. I did.
All right, you're charged with terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
Notice how carefully the judge explains this. Even if Allen pleads, the court isn't locked in. If the judge thinks prison is more appropriate, Allen could end up with way more time than he bargained for. That's the risk of plea deals. No promises until the gavel falls.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
I do.
Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No. No.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Yeah, he can appear by his own.
And here's the bargain. 3 years in prison with a $2,000 fine, but suspended for community supervision. Translation? He avoids prison if he follows strict probation, but if he slips even once, the court can instantly impose that 3-year sentence.
Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
And counsel, I believe we had any pretrial motions?
We did have some pretrial motions previously in this case, and they've been disposed of.
All right. Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, state tenders, what has been marked State's Exhibit 1 and all attachments.
All right, did you review any objections?
I have no objections to those
Oh.
pieces, Judge.
Mr. Allen, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right, any objections to the court reviewing the? Okay. All right, yes.
And so, Judge, as you can see, essentially what
Now, this is where the case turns personal. Alan's biggest concern? Not prison time, not fines, but being allowed supervised access to his son, Aiden. His lawyer pushes hard, saying Alan just wants GPS monitoring so he can still see his child and help his family. This is where criminal law collides with family law.
primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that that his GPS permit him to be monitored, that's fine if that's what the court desires. But he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court,
And here's the kicker. The judge points out multiple people listed under protective orders. Alan's lawyer insists some of them are custody lawyers or unrelated litigants. But protective orders mean zero contact, period. If Alan slips up here, his deferred deal could vanish in a heartbeat.
those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos, and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr.
I'm
Allen.
just saying, based the
They're-
judge's notes that you gave me,
So what do you think? Was Alan just a father trying to stay connected to his son, or was this a smart legal strategy to soften the blow of a felony charge? Deferred adjudication can be a second chance or a ticking time bomb. Drop your thoughts below, hit that like button, and subscribe for more shocking courtroom moments.